Hello all and good afternoon. Welcome to our next in live conversation with. I'm delighted to be speaking with Caitlin Jenkins this afternoon about trusts in divorce. Now, let me just get her in again. Let's see if we can see her. 2 seconds. Here we go. Let's just wait for her to come in. Everybody else can come in. Take your seats.
Hello.
Here we go. Hello, Caitlin. How are you?
Hi, I'm really well. How are you?
I'm okay. Just in a hotel lobby.
How exciting, though.
I'm just on a mini adventure. You know, you've got to get out of London.
Absolutely. Good for you.
Yeah. How are you?
Really well, thank you. Not quite such a glamorous location.
Well, I mean, you should see outside. There's a lot of building work going on. It's not too exciting, but I'll just wait for a few people to come in, and then we'll get a little brief introduction on you, what you do, and what we're going to be covering this afternoon, which I'm very, very excited about because trusts can be complicated at the best of times, and in divorce, it can be a total minefield. So you are the go-to girl when it comes to trying to figure out the best way to navigate this. So whilst everybody's coming in, I don't know, Caitlin, if we can give a little background on yourself. Yeah, who you are, what you do.
Absolutely. So thank you for having me on again, Lottie. Lovely to see you. So I'm Caitlin Jenkins. I'm a family lawyer and a partner at Mills Reeve. Mills Reeve's a national law firm, and we have family lawyers across the country. We act for all sorts of people going through separation and divorce, both those who've been married and those who aren't, both in the UK and internationally. And what we find is that where you really need Mills and Reeve on your side is if there's a complicating factor like trusts. So yeah, that's a bit about us.
Well, absolutely. And I think it's also quite helpful to just give a brief summary of what is a trust, because I think some people will be wondering, what is this? And they might not even know they have one. So what would you say?
Absolutely. So trusts take all sorts of forms. Sometimes you can have a trust that arises from a will. So somebody's left some money under a will to one person during their lifetime, and then it goes on to the next generation once that person isn't around. That would be a will trust. Sometimes you have old established family trusts, which is what usually people think about when they think about trusts. So they think about, say, for example, a farming or business family that's set up some trusts that have been running for generations, and that the ownership of assets is behind the trust wall, is owned by the trustees of the trust, but being held for a series of beneficiaries. So initially children, and then grandchildren, and then children beyond that. So it's a way. We're not going to get into the tax because that's uber complicated and not my favourite thing, but it's a way of assets being owned and then managed for the next generations.
Sorry, I've got some loud Spanish people. Sorry.
Right.
Can you hear them?
Maybe they want to hear about trusts. You know,
Well, they might do. I do. Yeah, I mean, but that's a whole nother ball game when you've got international trusts on top of that as well.
Yeah, absolutely. So there's lots of different types of trusts, and technically, even for example, sometimes people buying a house together, they're sort of owning a house on trust for somebody else. So lots of different types of trusts, which means there's lots of different types of implications for people who are divorcing.
Exactly. And I suppose if we're going back to the topic of divorce, if there is a trust, say a family trust that's set up by, say, the wife and her family, and then they're getting divorced, how would this be relevant? You know, if the husband's not part of that trust as such, what would that process look like?
So it can look like one of a couple of things. Most often where it's relevant is the courts, the family courts, or people negotiating, look to the extent to see that the assets of that trust or income from it is a resource. That's the key word, resource available to the family. So and that's part of the overall picture that family courts are looking at when people are separating. So what is there? What assets do people have, and what are they worth? So that might be a house, it might be a pension, it might be an income stream, but it might also be a historic interest or an interest that somebody's got in that family trust that you've just described. And so what the courts are concerned to understand, and the couple who are divorcing need to understand, is the extent to which that trust is, or sometimes isn't, a resource. So that could be, a resource could be various different things. It could be that, for example, a trust has loaned the money to one of the couple that's enabled them to buy a house. To what extent will that be a resource, again, going forward? It could be that the classic is school fees. So if you have a family trust that has been going for generations, and the trustees have always paid the school fees for the children, the payment of those school fees for those children during the marriage has been a resource that's been available to the couple in effect, because they haven't had to pay the school fees. So it's relevant, save in certain circumstances we'll look at when trusts can get even more involved and can be under attack is perhaps too strong, but under fire. It's relevant really to the extent it has or hasn't been a resource to that couple.
That's really interesting, because you would think, and I would think naively, that something that was set up for school fees as such would actually just be designated, and that shouldn't be something that would form a marital pot as such. But as you say, if that's taking the burden off the parents from having to pay for those fees, then actually that is an indirect resource for them.
Yeah, and it might not be regarded as part of the marital pot. So you could have a pot of money in this family trust that we've notionally set up for this couple, and that money in the trust wouldn't actually be a resource that's available to the couple as such. They can't get their hands on the capital, that's a trust asset. But the resource, the support that that couple have had during the marriage from that trust in this example is paying for school fees. So just thinking about the school fees bit, what might happen in that divorce might be that the courts say, well, we think because there's enough money in that trust and it can afford to do so, it's likely that those trustees who've paid for the school fees throughout the marriage will carry on paying for the school fees throughout the marriage. They can't force the trustees to do that. Trustees are separate, completely separate to the divorce. It's not their divorce. But they can use and they can assume, or judicially encourage is the rather legal phrase, that those school fees will carry on being paid if it looks as though it's affordable. So it's not a question of the money in the trust getting dragged into the actual divorce and added to the balance sheet. It's a question of going, okay, what resources it provided during the marriage. So school fees is the classic example.
And we've got a question that's popped up here saying, what if kids are put in a trust and parents separate? Not quite sure what you mean by kids being put in a trust. Is the children have a trust? I don't know if the question asker has got...
if we've got the right question.
Yeah, I don't know if they want to elaborate on that.
Well, if it's a question of some money's been set aside for children in a trust and then the parents separate, as in all trust cases, it'd be a question of, first of all, understanding the nature of the trust. So, and the couple would need to look at the documents that set the trust up, and then what it's been used for, and also sometimes a letter of wishes, sometimes disclosable, sometimes not, that explains what the person who set the trust up wants to use the money for. That may or may not be relevant. So if there's money set aside for kids in a trust, it would be a question of looking at why it was there, what it was set up for, what it's been used for, and then, as I say, be taken into account as this resource point.
Well, because that's one thing that just sort of struck in my head then is, from the point of separation, some parents might want to use that as a tool for avoiding to dilute the marital pot as such by gifting money into trust for children. But I suppose, again, the intention there and the timings would be looked at the court to say, are you just trying to reduce your balance sheet?
Absolutely. And so courts do sometimes find that trusts are a sham. So particularly, and courts take a pretty dim view, and therefore it's usually not a very sensible option to, we're getting divorced, I'm going to shove a load of money into a trust for children or somebody else, and at the time of divorce, the courts may well take the view in that circumstance of, well, hang on a minute, that's just done deliberately to get assets off the balance sheet of what's available to the couple, and regard that money as that trust as a sham, in which case they could potentially try and drag it back into the equation between the family. Yes. So, there are circumstances in which courts have said this isn't actually a genuine trust; it's a sham. Unlikely when there's been like a long-standing family trust that's been operating for generations.
Yeah, and also I know that sort of we've talked about prenups before as well. Is that something that somebody would use again to layer an additional layer of protection over a trust, perhaps?
Absolutely. Yeah, I always think of things like prenups, as we probably talked about this and we discussed it before, as a sort of a layer of barbed wire, a layer of separation between an asset and a couple for divorce. A trust can also be a similar thing. The money isn't actually in the couple's name. It's owned by trustees on terms set out in a trust document. And so having a prenup that also explains what the trust is and isn't for, as well as money in a trust, can be really helpful.
Interesting. So where could a court possibly change the terms of a trust, for instance, if it was set up and, you know, the trustees didn't agree with it anymore, or something like that? What do you?
Yeah, so there's sometimes trusts are regarded as a resource or not as a resource. So that's usually the first question that courts are looking at. Well, actually, no, the first one is probably, is this a real trust or not? So it's that sham trust point. If they decide a court thinks, well, it is a genuine trust and it's been set up in the right way with sensible reasons, then it'll be, well, to what extent has this trust been a resource available to the marriage or not? Sometimes trusts are completely irrelevant because the couple already have enough money elsewhere in all of their other assets to deal with their issues, and any money in a trust is non-matrimonial, it's never been touched, it's not been used for school fees or houses or anything, and it's completely irrelevant. But to answer your question, there are some circumstances which usually terrify trustees, in which the statute says that if a trust is nuptial, come back to that word, if a trust is nuptial, then on a divorce, in some circumstances, the family courts can adjust the terms of that trust because the trust is nuptial in nature. So the theoretical power is there for family courts, if it thinks it's necessary, to actually crowbar into the trust, change the trustees, transfer assets around, add beneficiaries. Now, I say theoretical because there's two major things. One, it very rarely happens. And one of the reasons it very rarely happens is the definition of what's a nuptial trust, which is the thing that takes you into this sort of arena, is really vague in the case law. It's not in the statutes. And case law differs between whether a trust has to be nuptial from the start, can become nuptial. And so it's never a good idea to be at the front end of a point of law in one's own divorce. And that really is at the sort of front end of what the development of the law is. So to answer your question, yes, theoretically, family courts can, in certain circumstances, actually go into the trust and rearrange assets and trustees. But it's only if the trust is nuptial, and it's rare.
And so going back to that definition of nuptial, when does it become nuptial? Like, when is a trust nuptial?
So I suppose a classic example might well be a trust that was set up at the time of the marriage, on envisaging the couple were getting married, and perhaps it provided for both of the couple as beneficiaries. So that would be the sort of archetypal sort of, well, it was clearly nuptial because it was envisaged at the time of the nuptials. Yeah. It was set up as part of the nuptials. You know, we're going to do this and this and this because you two are getting married in 2 weeks' time. And both of the couple were beneficiaries. That would probably be, theoretically at least, a very sort of nuptial settlement. All the flavours of it would be nuptial. But of course, most of the time, that isn't what happens. There's a family trust that's been around for generations, and maybe they've done some rearrangements, and maybe they've added in the spouse as a beneficiary, and maybe they've made some provisions for parts of the couple. Query whether that nuptializes, makes the trust nuptial or not. And as I say, the learned High Court judges differ on whether you have to fall within this rather esoteric bit of law. You have to be nuptial at day one, or whether you can become nuptial just because of the way that you've used the trust over years.
Can you remove a trustee? So, like, I don't know if there's sort of like voting rights or something like that. Say you've got 3 siblings and then the husband jumps in, and then they're like, the husband, we don't want him there anymore. Can they vote to take him off as a trustee?
So it would depend on the terms of the trust. Most of the time, that power doesn't rest with the siblings who would be the beneficiaries. You'd have trustees who are actually the ones who call the shots on the trust, usually. The trustees under most trusts, formalised trusts, would have a wide range of powers to do all sorts of things, including, usually not always, but adding to classes of beneficiaries, so adding somebody in, or often taking somebody out revocably or irrevocably. So it wouldn't rest with the 3 siblings who said, oh, you're getting divorced and we don't like your spouse. It would be most likely to rest with the trustees. And we advise quite a lot of trustees in this context as well, because as you can imagine, if you're a trustee in this circumstance, getting into the morass of one of the beneficiaries' divorce, it's a bit of a minefield. And so we actually end up often advising trustees sometimes as well, separately to the husband and the wife. But there's rarely, in most sort of long-established family trusts, you'd have mum and dad beneficiaries and then their children. So you've got your 3 siblings in your example. Rarely would you say, and sibling of a person and spouse of the first one, spouse of the second one, spouse of the third one, actually name them. But often they might fall within the class of beneficiaries as just and spouse of. So again, does that drag the trust towards the relationship? Does it drag it towards the marriage just because they're a spouse of a beneficiary? It's all really, really dependent on what the family and the trustees have actually done during the course of the marriage. So it's really, really fact specific.
And I think that's quite crucial as well for people to be aware from that on the outset. You know, they might be like, oh yeah, you know, like having a joint bank account, having a joint trust or something like that, but actually the repercussions if things do go a little bit sour might not be that great for the remaining beneficiaries on there as well if it became muddied.
And that's where one of the reasons why it's important for trustees to get advice, because trustees have to think about not only sibling one who's getting divorced, but they also have to think about all of their beneficiaries. They have to think about sibling two and sibling three, and also the next generation and the generations beyond, depending on the terms of the trust. So, and trustees also have to act unilaterally, as I understand it. Sorry, not unilaterally. They have to act together. They have to agree. Yeah. So it's a sort of long-term future planning tool, usually a trust, and it isn't just about one generation. They have to think about the future generations too, and that's quite a lot to balance up. Hence why they usually need advice as well.
Well, and I think that's really important to say about the trustees as well. Usually you would hire a trustee who is totally independent, but I think sometimes what happens when you do get the disputes is when you've got too many family members or external family members on one side of the trust who have got that weighting towards the beneficiaries who may not like. Is that something that you might see?
Yeah, that's right. And trustees, a bit like trusts, come in all shapes and sizes. So you could have a family trust that's uncle and aunt are trustees, or the aunt is the original beneficiary. The original trustee is, say, the aunt and, say, a lawyer or the accountant who've been working with the family for years. So you could have one professional trustee and one individual as a trustee. Sometimes trustees are trust corporations, particularly international trusts. So if you have a trust based in Jersey or Guernsey or Bahamas or Bermuda, you will have a professional trust company who is the trustee, who is paid to administer that trust in accordance with the way it was set up and having a regard to all of the beneficiaries. So sometimes the trustees are quite close to the family, or there's overlap with family members. Sometimes they're really independent. But either way, the trustees have duties to think about the management of their trusts going forward.
And so if the trustees weren't acting in line with what the beneficiaries were expecting, would there be any wiggle room for them at all in that respect, or not? Are you really at the mercy of what the trustees are dictating almost?
So it depends on the terms of the trust, and there's some complicated stuff about, you can have protectors and sort of fallback plans if you're not happy with the trustees, and sometimes powers to change trustees rests with some of the beneficiaries. So it really depends. But I mean, the most important thing for a family who has got a long-standing sort of trust set up is to have really good documentation setting up why they've set it up, being really clear within the family, irrespective of divorces, about this is what we are going to use the money for, this is what we're not going to use the money for. And for the trustees then being able to be prepared to act in accordance with that. But fundamentally, it's, as I understand it, I'm not a trust lawyer, I'm a divorce lawyer, as I understand it, it's up to the trustees to administer the assets in accordance with the terms of the trust. So you can, and quite often, even ignoring divorce, trustees, because they have to balance up the interests of everybody, may say no to requests for money. They may say, well, I know you've asked for X, but no, we can't, the trust can't afford that. And we have to think about, sibling B and sibling C. So, yeah, the trustees are independent and have to make informed choices, really.
Yeah, that's really interesting. And so I guess there's three areas that we've covered there then, in a sense. So it's individuals who have a trust coming into a marriage, it's individuals who marry somebody who's got a trust, and then you've got the trustees. They're the three sort of the key components that you've got here when dealing with a trust in divorce. And I don't know what your sort of tips would be for each of those sort of parties.
Yeah, so I suppose the first thing is to say, as you'll have as we've discussed, it's complicated and the answers are not obvious. So I think for all three categories, it's kind of take a breath and get some advice broadly. But maybe as I'm a lawyer, I would say that. But actually, looking at it from the perspective of the person with the trust, I suppose the thing I'd say is, if they're divorcing, is don't panic, I suppose, is probably for all three categories, but don't panic. Understand what the implications of the trust are, and importantly aren't, for your divorce, because it may be that there's a stash of cash in a trust that's been there forever and you've had very little benefit out of it and can get very little benefit out of it, in which case it may be broadly irrelevant or not that relevant, depending on the rest of the assets. So I suppose if you're the trust, the person with the interest in the trust, top tip would be understand exactly what the nature of your interest is and isn't, so that it can then be presented to the best. I suppose if you're the person who's married, so you're the other person who doesn't have the trust interest but your spouse does, again, I'd say perhaps don't get too overexcited about the prospect of there's this money that's been in the family for generations and you're definitely going to get one's mitts on it. Again, pause, get the information. Family law world is full and frank disclosure of all financial circumstances anyway, and then get good advice about what the implications are of it for your divorce. So don't be too overexcited by it, but also really understand the extent to which it really is relevant or isn't relevant in your divorce. And
because I guess one thing on there, I'm just going to butt in, is, so say you've got loads of different assets. So you've got sort of investment portfolio, you've got properties, but they're all under the same umbrella. Say you were getting income from the investment portfolios that were nuptial, but the properties weren't. Would that make a difference, or is it all under one canopy? If that makes sense.
So you're saying it was all under the trust canopy?
Yeah, so say the trust is holding the properties and bank accounts and, you know, maybe they haven't structured it so sensibly, and, you know, investment portfolios, but if they're using income from the portfolio perhaps, would that then bring them all under the nuptial roof?
It might do, or it might bring them under a resource roof. But fundamentally what the courts want to do is to make sure that people's needs have been met.
Yeah.
And they want to make sure that people's needs have been met primarily from the assets that they've got in their own names or joint names that are theirs, so not outside trusts or companies or anything else. They fundamentally want to look at what those easily available resources are, and they want to share those if they've been built up during the course of the marriage. Yeah. The gloss of trust assets or income is whether it's adding to those resources or could be available to help with those resources, or if they've never been used at all and the trust has never provided any financial support at all to the family and has been in the family for generations, it could be completely non-nuptial and completely irrelevant. So it's really fact specific as to what's under the umbrella, what's you know, outside in the rain, and what's never been touched or provided anything.
Okay, that's really helpful. And then going back to your third point in trustees and what their top tip might be, you know, apart from coming to see you first.
Of course, obviously. I think trustees tend to sort of, their instincts tend to go one of two ways. And I always try and get the trustees to think a bit more broadly. They either instinctively think we're trustees of money that's been in the family for generations, it's completely irrelevant, it's behind a trust wall, back off, don't ask us questions. Yeah. Or they panic because they've heard this stuff about nuptial settlements and they think, oh my goodness, it's all going to get terribly difficult, and they get quite defensive. My advice to trustees is usually, again, a bit like the couple, pause, explain to me the basis of this trust, what it has done, what it hasn't done, what it's provided, what it hasn't provided. And don't be too defensive about it, because it could be that providing the basic information and the story about the trust, that actually that answers the questions for the couple or the couple's lawyers, and it's, oh, well, it's broadly irrelevant, or well, it's going to pay for, it looks like it's always paid for school fees but nothing else, and there isn't a lot of money in there anyway, and it'll just about pay for school fees going forward. So I think for trustees, it's A, don't be too defensive, and B, do get advice, because you may, as often is the case with divorcing stuff, sometimes people worry about things they don't need to worry about, or they don't worry about stuff they really should be concerned about. And I think trustees need an early call as to the extent to which they should be concerned and involved in this divorce or not. Yeah,
and I think as well, when especially in divorce, it's people bottle up, they freak out, and then the communication lines get dropped, and that's where more panic comes in. That's where more irrational decisions get made. And actually, there is usually a very logical way of setting things out. And I think it's also when people are trying to do something a bit cheeky that it gets even more complicated, because they will be like, this isn't it, and then they cause even more problems and costs and everything like that by just not being straight from the start.
Exactly. And I think the other problem is that often people don't necessarily know what their interest in the family trust is. They just sort of know that the family trust owns the family business, and every now and then they get a dividend through the trust or something like that. Or, well, the trust has always paid the school fees. But they don't actually know. They don't have to hand a copy of the document setting it up, or they don't know what other decisions the trustees have made. So often you're asking clients questions they don't really know the answer to, because it's a sort of family thing that has just sort of carried on forever and they've never really known the details. So again, it's about understanding the nature of it and then advising on the relevance of it or not to this couple's divorce, really.
Well, yeah, and then the disclosure as well and the documentation with that, again, because from personal experience, I find that the way that trusts are documented is very vague, because you'll literally have, this is a trust, nice little, contract, and it comes with the trust assets. And that will be a totally separate document that's somewhere else that nobody can find.
Absolutely. And trust documents are drafted deliberately generally. So it'll often say, and the beneficiaries are, Mr. A, Mrs. B, and their children, and their remoter issue, and their spouses.
Yeah.
And then it'll also say the trust assets are £10 or whatever's been added to the trust, and then you're scrabbling around or what else is in the trust. And then it'll also say, and the trustees have the following powers, which will run to about 20 pages to do all sorts of things. But that's because the trust lawyers set it up in that way to be as flexible as possible, to be able to adapt, correct, to be able to adapt and change, particularly for tax reasons, because often it's about, oh, well, we'll do it this way for a while because the budget has said, whatever it says next week about taxation and inheritance tax and things. So they are generally broad, most trust documents, but the important stuff is often not necessarily on the page of the documents, but what's actually happened in practice.
You need to find a way to blockchain trusts or something like that. I think that would be quite useful, wouldn't it? And people have less places to hide. But sorry, I'm going to keep rambling on. I find this so fascinating. But thank you, Caitlin, so much. I'm aware we're coming up to time now. Are there any points that you'd like to make that you don't think that we've covered?
No, I think it's just, it's one of these areas that when you shine a light into it, it looks initially terrifying, mainly because people they either don't understand the nature of their trust, they haven't seen the documents, they don't understand the documents when they see them, and there's some quite scary possibilities as to why it could be relevant, and sometimes it's highly relevant. So I just think it really is one of those areas, and maybe I would say this is a solicitor who specialises in this stuff, where you do need early advice, because it could be that early advice saves you a lot of heartache and actually fundamentally a lot of money, to actually understand whether it's a real problem or advantage or not. Yeah,
absolutely. Well, wise words. Thank you so much, Caitlin. And I will share your details for where everybody can find you. And yeah, thank you so much again.
No problem.
All of this.
No problem.
I will see
nice
you
to see you.
I'll send you some sunshine.
Lovely. Safe travels. Enjoy.
Thank you. See you later,
Bye.
Caitlin.
Bye-bye.